On February 24th, 2011, Major Kevin Tice of the Nevada Highway Patrol sent out an email. The email said that officers involved in NHP's K-9 program were not allowed to discuss the program with anyone outside the department. Some NHP officers alleged that the policy was designed to prevent officers from making the problems in the K-9 program known to the public, and the officers alleged it was a violation of their First Amendment rights. In this week's video, we'll take a look at Moonin versus Tice, a 2017 Ninth Circuit case involving First Amendment rights as a government employee. I'm Steve Serbalik, and I'm a panel attorney for ASCOPS in Arizona. For context, here's a quote from Tice's email. Effective immediately, except for allied law enforcement agencies and high-intensity drug trafficking area representatives, there will be no direct contact between K-9 handlers or line employees with any non-departmental and non-law enforcement entity or persons for the purpose of discussing the Nevada Highway Patrol K-9 program, end quote. The Ninth Circuit held that the policy imposed by Tice's email violated the First Amendment. This was because the policy covered speech undertaken outside the officer's official duties and on matters of public concern. The court also held that Tice had failed to show any past disruptions sufficient to justify the policy, nor did he demonstrate that any harms anticipated were real, not merely conjectural. Public employees have the right to comment on matters of public concern, particularly if these comments are made in their private capacity as citizens. So a policy that would stop officers from discussing non-confidential aspects of their work is unconstitutional. Finally, the court held that it was clearly established in 2011, when Tice sent the email, that such a broad prior restraint on employee speech could not survive First Amendment scrutiny, because it was already a well-established principle. Tice was not entitled to qualified immunity. There are a few important takeaways in this case. 1. Administrators and supervisors cannot impose sweeping gag orders on government employees, particularly when the policy would restrict speech that occurs outside of work. 2. Courts have determined that the first factor I just mentioned is a well-established principle. 3. Because it is a well-established principle, those who do impose such restrictions are likely to not be entitled to qualified immunity. Now, be careful, as agencies can restrict on-duty comment. Employers can restrict what an employee says while they're on the clock or while they're speaking in an official role. The constitutional protections that exist ensure that employees, just like regular citizens, can speak in their private capacity on matters of public concern, including about the operations of police departments, for example. If you have any questions or comments, leave them down below. Please don't forget to like, follow, and turn on notifications. It really helps the channel grow. Be on the lookout for new videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching, and stay safe out there.